Good morning, everyone. Welcome to King's Chambers Construction webinar. Thank you all for joining. I'm Andrew Singer. I'm one of the members of the construction team at King's, and I'll be chairing this session, which features an array of talent from our construction department. They are in the order in which they'll be speaking. Jonathan Ward, who's going to be giving us an adjudication update, particular reference to recent cases about the use of Part 8 procedure as a means of avoiding or attempting to avoid adjudication enforcement. Sarah Lawrenson is going to be speaking about the possibility or the prospects and the practicalities of a low-cost regime in the TCC. And Oliver McEntee is going to speak finally about about enforcement of adjudications in contracts where the dispute resolution procedure is other than court, notably arbitration. Each of the speakers is going to be about 15 minutes, which will allow us about 10 to 15 minutes of Q&A at the end before we have to finish at 10. If you want to ask any questions, please use either the Q&A function or the chat function. I'll be monitoring them both, and I'll try and pick out some of the questions towards the end. We'll ask questions all at once at the end rather than during the process. So without any more, thank you again for joining us, and I'm going to hand over to Jonathan.
Thank you, Andrew. I'm just going to share my slides. So as Andrew says, my talk is an adjudication update, and there will be two main themes to the talk. Firstly, Part 8 claims in the context of the enforcement of adjudication awards, and secondly, challenges to the validity of payment applications and arguments about waiver in that respect. And as we will see, these two themes will often arise in the same cases. So I'm going to start with a fairly recent Court of Appeal decision of A and V Building Solutions against J&B Hopkins. Citations there on the slide. So I'll begin with a quotation from Lord Justice Coulson, who gave the leading judgment in the Court of Appeal. He said, "One thing, however, is clear. The guiding principle of construction adjudication, namely pay now, argue later, has been comprehensively ignored by both parties in this case. How that happened and how it is to be avoided in future cases forms another element of this judgment." So with that introduction, the facts in brief: JBH engaged A&V to carry out M&E works. There was a written construction contract, and that contract entitled A&V to monthly interim payments, and the payments were to be made, quote, in accordance with Appendix 6. So Appendix 6 provided for a series of dates for each interim payment, and as we can see on the slide, these are the relevant dates for the interim payments in question. So there was a fixed date for the application, valuation, the due date, etc., etc. And at the end, there was some further text which, amongst other things, said, "For the avoidance of doubt, if applications are not received from the subcontractor 7 days prior to the valuation date, then the subcontractor shall not be entitled to any payment until next valuation date." So that's what the contract said. What actually happened: application 14 was submitted on the 22nd of March, a Monday, instead of the 21st of March, as specified by Appendix 6, which was a Sunday. A payment notice was served by JBH, which said that there was no sum due. And I'll pause there to note that this was not a smash and grab adjudication in the sense that there was a claim for a notified sum and no pay less notice. This was a true value adjudication. So the parties were in dispute as to the valuation of the interim payment. It went to adjudication. JBH defended the adjudication on the basis, they said, that there was no valid payment application. And this was the first time they raised the point in response to the adjudication. And again, pausing to note that this type of defence seems to have become increasingly common. and it can end up making adjudications quite technical. But anyway, the adjudicator disagreed with JBH's argument and held that the application had been validly made, and so he ordered payment in favour of A and V. The award wasn't complied with by JBH, didn't make the payment. So far, so ordinary, you might think. This is where things became a little more interesting, because having succeeded in the adjudication, A and V didn't immediately apply to enforce the award. Instead, they waited some 2 months. And to a large extent, that seems to have been due to JBH's decision, so the losing party's decision, to commence a Part 8 claim. They actually commenced that prior to receipt of the award, so they presumably saw the way the wind was blowing and issued their own claim for a final determination as to the validity of the payment notice. So that Part 8 claim was issued. A and V did ultimately issue enforcement proceedings, but for some reason didn't, I don't know if they sought to consolidate it, but the proceedings weren't consolidated with the Part 8 claim. And so the first hearing in the TCC was just a hearing of the Part 8 claim. And that went before Mr. Justice Eyre, and he effectively ignored the adjudication award and simply decided the Part 8 claim on its merits. And he decided that the original application, the payment application, was not valid. He said it was not made on the specified date in Appendix 6. It was made 1 day too late. And so there was no entitlement to payment in that payment cycle. The adjudicator was wrong, and there was no sum due. Part of A and V's argument was that such a construction of the contract was unfair. The judge said, well, the result couldn't be unfair because that's what the contract said in black and white. And he rejected A and V's argument that JBH had waived any breach of the requirement in Appendix 6. So that was the outcome in the TCC, and A and V then took the matter to the Court of Appeal. As I say, Lord Justice Coulson gave the leading judgment with which the other members agreed. And the first issue on the appeal was whether the Part 8 claim should have been entertained at all in the context of an extant adjudication award that hadn't been complied with. So there was argument on that. Lord Justice Coulson referred to previous decisions in such cases, and he said that the position remained as he had set it out in Hutton, which was an earlier case of his in the TCC, and that is, the court should deal with the adjudication enforcement first, then sort out the Part 8, unless the point raised was straightforward and self-contained, and the parties were agreed that it could be dealt with at the enforcement application without adding to the time estimate. And he cautioned against an overly liberal approach to Part 8 claims in this context, and parties re-arguing the substance of the adjudication at the enforcement hearing, because that would defeat the whole purpose of the adjudication regime. And he also referred to the relevant parts of the TCC guide, which cover Part 8 claims in enforcement proceedings and when it's appropriate and permissible to bring a Part 8 claim and for it to be heard alongside an enforcement application. So applying that to this particular case, he said that the judge was right to hear the Part 8 claim and not to strike it out, but that he should have approached the hearing in a different way. He said, we can see on the slide, the judge should have considered the Part 8 proceedings through the prism of ABB's successful claim in the first adjudication and the decision of 19th January in their favour. So put another way, although the application to enforce hadn't at that time come on for hearing, nevertheless, the judge ought not to have simply decided the Part 8 claim without reference to the outstanding adjudication award. So what should have happened, he said, is that the adjudication award should have been considered first and enforcement ordered, subject to any arguments about jurisdiction or natural justice, and then subject only to the question of whether JBH could succeed on its Part 8 claim. And see also a very recent TCC decision, the citation is on the bottom of that slide, which applied the approach outlined and confirmed in A and V in the TCC in the context of competing Part 8 and enforcement actions. So that was in terms of the general approach, that's what the Court of Appeal said. Now let's look at the substantive issue, which was the validity of the payment notice itself. Lord Justice Coulson said the following: the judge's approach was simple. The date of the 21st of March for the relevant interim application set out in Appendix 6 was described as a condition precedent in Clause 9.2, so it did not matter if that day was a Sunday or Christmas Day. The date was sacrosanct. If that date was missed, the entire application was invalid, and AVB had no entitlement to make any claim for that monthly cycle. But actually, he said it was more nuanced than Mr. Justice Eyre had thought. We really need to look at the full contractual wording, as is often the case, and especially the whole of Appendix 6. Sadly, we don't really have time to go through all that. But essentially, the Court of Appeal considered that the overall effect of the wording was that some flexibility was envisaged and that the dates were not set in stone. And they noted in particular the additional provision which I read out earlier in Appendix 6, which came after the tabulated dates, that said that where applications were not received at least 7 days before the valuation date, no application would be considered until the following month. So the effect of that, it said, was that although there were a series of specified dates, there was also a hard deadline, a long stop, and that was actually 7 days before. So in this case, the 24th of March, not the 21st of March, which was the specified date, and the application was made on the 22nd. It wasn't on the specified date, it was a day late, but nevertheless, it was still in time. So it's actually worth reading this part of the analysis in the case, because there are some interesting comments and observations about the general approach to this type of provision and contractual structure, where there are general provisions in the body of the terms and then more specific provisions in the appendix. But anyway, the result was that the application was validly made and the adjudicator had been right. And I thought equally interesting was the decision in relation to waiver in this context, because, well, A and B basically had two arguments on waiver. I'm only going to deal with the second because the first was unsuccessful. But recall that the focus of the adjudication and of the TCC hearing and much of the appeal was on the validity of interim application 14. But actually, as we saw earlier, that point, no point on validity, was taken by JBH at the time the application was made. The application was dealt with by JBH as to its substance, and the argument as to validity was first made in the adjudication. As we can see on the slide, they dealt with the detail of the application, and in Lord Justice Coulson's view, they unequivocally affirmed the validity of application 14 in doing that. And if they had taken a point, it would have been open to A and B to have made a fresh application for the same amount the following month. So Lord Justice Coulson was plainly unimpressed with this type of tactic. It is, I have to say, quite common. But it seems these days to be a rare case where the paying party unequivocally accepts the validity of the underlying payment notice and simply deals with it on the merits, at least once things get contentious in adjudication. But Lord Justice Coulson indicated, in my view, that this type of argument is going to get short shrift unless the validity of the notice is challenged right at the outset. So we can see what he says in this regard. If I had had to decide this issue at first instance, I would not have permitted JBH to conduct themselves in this way. Consider, therefore, that the judge was wrong not to find that JBH unequivocally represented that application 14 was valid. So if there are points of validity to be taken, they must be taken on receipt of the notice. Now I'm going to look briefly at another decision in a similar context, Elements and FK Building. And if you have any questions, you could feel free to direct those to Andrew Singer, who represented FK in this case. But this was another Part 8 / enforcement decision. There was a contract for building works. I've set out some of the relevant contractual wording on the slide. Essentially, Elements made an application which wasn't paid and then adjudicated and won. FK issued a Part 8 claim for a final decision on some of the contractual points, and Elements issued enforcement proceedings. The enforcement claim and Part 8 were heard together in the TCC in this one, and there was no dispute that the award was enforceable and would be enforced, subject to the outcome of the Part 8 claim. So the court was only really concerned with the Part 8 claim. FK's argument was that the application had been made late and so was invalid, similar to in the earlier case we saw, and this turned on where the application had been received, which was the word used in the contract. And the contention was that the word received, in contrast with the word given, which is often used, meant that the application had to reach its intended recipient by a certain time. And FK said that reading the contract as a whole meant within working hours. And so if the application was received late in the day, as it was, it would have missed the cutoff and be invalid. But the judge, Mr. Justice Constable, considered various materials and authorities on the meaning of day, and to cut a not so long story short, the judge rejected that argument and said, amongst other things, the law does not count in fractions of a day. The parties are free to do so in their contract if they wish, but here they had not done so. So the application was found to be in time. Perhaps more interesting are the comments about Part 8 claims in general in this context, because elements had challenged the ability of FK to litigate the issues at all in the enforcement context. They said that these issues weren't suitable for Part 8 determination, and recall that in the A and V case, which we've looked at in the Court of Appeal, Lord Justice Coulson relied on an earlier decision of his called Hutton. And this was relied on by elements. And we can see that there's a passage from that on the slide. He said that they said that Hutton established a higher threshold. And if we look at the text on the slide, we can see words such as beyond any rational justification, obviously wrong, and similar. So what elements were saying was that this imposed a higher threshold. And if you wanted to bring a Part 8 claim to resist enforcement of an adjudication, it had to be one where your arguments were very obvious. You can see why they might have said that, but the judge rejected that argument. You can see the rationale there. He said that in Hutton, those were merely examples of the type of case that would be appropriate. So I think in terms of takeaways from these cases, we can see that in the Court of Appeal case, two experienced construction judges had taken very different views in relation to the validity of notices. It shows why these arguments can get quite technical at times. And it somewhat detracts from what's supposed to be quite a straightforward and cost-effective process. Nevertheless, I think that in general, the courts are going to be somewhat flexible in interpreting these provisions and will take a commercial view so that they remain usable and don't present too many traps. And I think the other takeaway is that when you receive a payment application, if there are points of validity to be taken, that is when you take them. They shouldn't be kept in reserve for an adjudication. So that's what I'm going to say about adjudication, recent adjudication cases. And I think next Sarah's going to talk about low-cost regime in the TCC.
Yes. Following on really from what Jonathan has said, adjudication is designed, whether it is in practice, to be a low-cost regime, a short, sharp, quick process to get money flowing. But what happens when you are unable to take advantage of adjudication, for example, in domestic homeowner cases, or simply where you don't want to go down the adjudication route? Are you then forced into a situation in the TCC where disproportionate time and money is spent dealing with what should be capable of being dealt with in a more efficient way? His Honour Judge Davis certainly considers that there is scope for reducing the costs in the TCC in certain cases. This is a case that goes all the way back to the early part of 2022. The Sky's the Limit Transformations Limited and Dr. Mirza. It's a very familiar factual situation that many of us have come across, whereby we have a renovation, two-storey extension and renovation of a domestic property, Dr. Mohammed Mirza's home, and Sky's the Limit Transformations Limited undertaking those construction works. And we ended up with a fully contested final trial before His Honour Judge Stephen Davis sitting in Manchester that required a 5-day trial. So the basic case, as you can see there, related to unpaid invoices of about £120,000. There was no counterclaim The defence from and on behalf of Dr. Mirza was simply that he had paid enough, that there had been enough paid throughout. We ended up, or the TCC ended up with a 5-day trial with 8 experts. It had initially been heard before the then TCC district judge in Manchester, who, because there were already experts on either side, had allowed 8 experts, 4 on each side, to move forward and listing it through to the final hearing that was heard by His Honour Judge Davis. And what we see at the very beginning of the judgment in paragraphs 6 to 9 is His Honour Judge Davis saying, in my view, concrete steps to address the challenge of finding a time and cost-effective means of fairly resolving domestic property renovation business contracts disputes is required. The idea being that, of course, it's not proportionate to the overall cost, and that too much court time is taken up in dealing with these matters. As I say, in paragraph 6 to 9 of the judgment, His Honour Judge Davis suggested a way forward in terms of directions for dealing with these matters. And for those of you who over the past year have come across these, it isn't simply a case of the parties notifying the TCC that they consider that this might come within the bounds of sky's the limit, and therefore wanting at the CCMC to put forward directions on that basis. Certainly in Manchester, when the directions, when the order is sent out listing the first CCMC, what is happening is that on many occasions where it's considered that this is appropriate, that is being directed to the parties that they consider sky's the limit and Mirza in the directions or the approach that he's taken within paragraph 6 to 9. So, and there, in my view, there have been changes to paragraph 6 to 9 and the approach that's taken in particular cases. But if we look at the proposed directions that His Honour Judge Davis was making, disclosure should be limited to documents relied upon and known adverse documents. Of course, that doesn't go against the disclosure pilot, and there is provision within the pilot that would allow for such direction. But of course, it's quite different to what we normally see. And of course, particularly in the case of Sky's the Limit itself, there were technical arguments on contract formation, what the clauses of the contract were, etc. But this is limiting documents quite a bit. At B, single joint expert to address both liability and valuation. One expert dealing with everything throughout. Even, it appears, His Honour Judge Davis is saying where there are already experts instructed. We jettison the experts that are currently instructed, and both sides instruct one single joint expert. The court will appoint one single joint expert to deal with everything. There will then be a stay for mediation or an order for compulsory ENE. ENE, early neutral evaluation. You go before a different TCC judge to the judge who will hear the eventual trial, and you get non-binding views on the position. I've placed in bold there the word compulsory. That is a word that comes from the judgment, but of course, I'm certainly not convinced the court has the power to order compulsory ADR in any event, but certainly the indication is that if the parties won't agree to a mediation, then that is what will happen. Finally, witness statements limited to the matters remaining in dispute and limited in length or number. Again, we've got the new witness statement pilot that is running, but again, I can't see that is contrary to that. There is certainly the power within the civil procedure rules to do that, but of course consideration would need to be given by the parties to how many are genuinely needed, and whether at this point, particularly if the single joint expert hasn't yet been instructed, how you define what the matters remaining would be, whether you need to do it at the first CCMC or whether there needs to be some later agreement in relation to that. What I've then called the more unique directions. Again, I'm not seeking to say that these go outside the civil procedure rules, but certainly they are not the normal position that we would see. And here we have a trial which will not normally exceed 1 day in length. as I've already said, this was a 5-day trial before His Honour Judge Davis. But significantly, each party produces detailed written opening submissions in advance. The last case I did where similar directions to this were ordered, they were to be limited to 40 pages. So certainly detailed, but I'll come back to whether or not that saves any cost. But detailed written opening submissions in advance, no oral openings, no more than 1 hour each for cross-examination of witnesses. Well, of course, that goes back to the earlier direction in relation to witnesses. If each side has only got 1 hour for cross-examining the witnesses, you really can't have many witnesses, or certainly not witnesses who are going into great detail on any matter. Single joint expert to appear remotely, and again to answer questions for no more than 1 hour, and finally 1 hour each for oral closing submissions. Judgment will then be oral or written, but will be a summary, will not necessarily be a full written judgment, full oral judgment. It will be a summary of what has been heard. And then extending the time from 1 day, the suggestion is that there will be half a day pre-reading time for the judge, ideally the day before, so the parties don't need to attend. And then the day after would also be further judicial time. So actually 3 days of judicial time in total to produce a written judgment or give oral judgment. One of the concerns, of course, in relation to if there is going to be an oral judgment is that your advocate can't excuse themselves for the second day, although it's proposed to be on the basis that it will only be 1 day, i.e. counsel, witnesses, etc. would only be required on the second day. If there's going to be an oral judgment, diaries would have to be kept clear for that afternoon to come back. And perhaps significantly, given that I've talked about costs, is that these were the actual figures given, not in that case, of course, because this is judgment, but what the approach should be in relation to cost management. Of course, if there has been a CCMC listed, which in all of these cases there are, the parties have to consider budgets and doing budgets. But the suggestion by His Honour Judge Davis was that costs in such cases should not exceed £25,000 per party for the approved costs. Of course, approved costs don't include the costs already incurred, but the proposal was that disclosure will be limited to £2,500, £5,000 in total for the expert, which would per party, so £10,000 in total, which would include the hour of cross-examination or questioning that is to be allowed within the trial, £5,000 per party for the mediation or the E&A, £2,500 for witness statements, and £10,000 for the trial prep, trial and post-judgment matters. And the basis upon which the judge's thoughts, as I say in paragraph 9, he's not suggesting that it is appropriate in every case or that it's some sort of panacea that will solve the problem of disproportionate costs. The idea being is that getting a single joint expert, many of these cases do stand or fall on expert evidence, expert valuation, etc. That although the trial judge, of course, has the power to go behind, in most cases that simply doesn't happen, or that the parties can take a view themselves as to which parts the expert may have gone off on a frolic or got it wrong. So you're front-loading that analysis, albeit not by the court, but by an expert, but a single joint expert. And therefore, both parties are, to some extent, stuck with it. And then, of course, there is the compulsory mediation or E&E to allow the consideration of that. His Honour Judge Davis considered that that was more fair, in that, in his opinion, it's unlikely that a full trial process actually results in a significantly different result being produced. That where you have an unreliable, dishonest witness, that comes out in a matter of minutes upon cross-examination, and actually is often visible from contemporaneous documents because they simply don't match, and that the cross-examination is easy. It's simply taking the witness to a document, and therefore that is unlikely, unnecessary, with these cases generally turning on rather than what people's recollections are or what happened, at meetings. It's the contemporaneous documents and the expert evidence. My thoughts in relation to this, well, we are seeing it in Manchester TCC. I haven't yet seen it used beyond. I say used beyond. I'm aware of advocates counsel who have tried to get, and to some extent have succeeded in getting these sorts of approaches, low-cost approaches, prompted directions, etc., in relation to these. It's only in Manchester where I have seen the direction being given to the parties to consider this case and to consider the approach that is taken in paragraphs 6 to 9 being considered by the court, i.e. essentially being forced. What approach do you take then if you consider this might be, whether you're pre-issue or perhaps putting in your defence, is it safe to avoid all the more stringent TCC guide approaches and civil procedure guide approaches in relation to disclosure, experts, etc.? The answer has got to be, if you consider that this is a case, whether it's the claimant or the defendant, where this is an approach that you would appreciate, your clients would find it useful to limit these what can be extraordinary costs. Try and get that agreed up front. Try and agree that approach. Of course, that's likely to be very difficult because you may well have one side who is in a stronger position of power in relation to finance and so doesn't want to do that, wants to use the threat of escalating costs. One thing I would say is certainly in Manchester, I'm not seeing that these are limited to residential homeowner disputes, as the case itself suggests it might be. The last case in which I was involved, in which a direction was given in relation to, or consideration was given in relation to this, was a piling case for unpaid invoices. Both parties were commercial. The counterclaim was for damages and loss, far exceeding the £60,000 of unpaid invoices. Whilst the claimant in that case, who was seeking £60,000 of unpaid invoices, was very keen to go down this route, the defendant wasn't. The defendant had put in a budget that ran to some £250,000 for a dispute that in total was worth less than £150,000. And again, that was his Honour Judge Davis, who at the CCMC didn't order the very specific directions that we've seen on the previous slides, and didn't order that budgets were limited to £25,000. However, the approach that was taken certainly significantly reduced the budgets down, I think, to less than £50,000. And again, there was a lot of emphasis on counsel producing documents, the parties producing documents in advance of the trial. In that case, there was to be a narrative of the defendant's case. That was in relation to delay. Again, 40 pages was to be done, no more than 40 pages of narrative of what their case was in relation to delay. A response back, again limited to 40 pages before witness statements were done. I have to query in my own mind, that may save court time. It certainly is very expensive in my view, in relation to the time that it takes counsel. Although, of course, we fully prepare for any trial, having to put those thoughts in writing to the point where you're content to disclose them to the judge obviously takes a considerable amount of time and discussion between not only counsel but instructing solicitor and indeed the party. Given that we've all got on this scheme £10,000 for the entire trial process, including post-judgment issues, one really is looking at a summary approach in relation to these matters. And whilst this is designed to be a bit like adjudication, not necessarily fair, but getting there quicker, I'm not convinced it's necessarily going to save costs, unless it were a formal approach that everybody got used to doing. There also seemed not to have been consideration of the shorter trial scheme that exists in the TCC anyway, and whether or not that would be a better and safer approach for everybody, given that the civil procedure rules already allow, and the TCC guide already allow for it. So we're a year on from this judgment, so I certainly can't say that it's disappeared. As I say, directions are being given, but I also wouldn't say that this is a regime that everybody needs to now adopt, now get on board and start dealing with. They do need, and I think there is definitely a push within the TCC to start looking at, rather than the all singing, all dancing Rolls Royce you can have as long as you want for a trial and consideration and as many experts as you want. How do we get to what is essentially the same result in a much shorter and quicker time? For me at the moment, the balance is in relation to saving court time, which for the parties is not necessarily where the significant cost is. So I'm not convinced at the moment that this is going to revolutionise it, or be the panacea, albeit is on Judge Davis accepted that this is that this is not that. And on that, I will hand over, if I can, to Oliver.
Good morning. So the matter I'm going to deal with briefly this morning is the issue of adjudication, enforcement and contracts that provide for arbitration as the final means of dispute resolution. So it's a relatively narrow point, but it has been raised in two very recent decisions, Sefton and Allen Build, and Northumbrian Water and Doosan. I appeared as counsel in the first of those cases, which has a rather more involved discussion of the issues, and I'll probably be focusing on that. But the case of the Doosan case that followed it raises essentially the same issues, and they were resolved in essentially the same manner. Both cases involved in adjudication enforcement claims. In the Sefton case, that was under the NEC 2 Option C contract, which had certain bespoke amendments. And in the Doosan case, it was the NEC 3 Option C contract. Both contracts are materially identical in terms of the way they structured dispute resolution procedures. And these cases here both raise the same inherent tension between two policies. On the one hand, you have the pay now, argue later philosophy of the adjudication regime, and of course that would risk being thwarted if parties were able to insist that following an adjudication decision, the matter then be referred to an arbitrator to make a declaration as to the effectiveness of the award. And while, of course, concerns about the speed and cost of the arbitral process can be somewhat overstated, the reality is that in such a scenario, one would have to jump through all the hoops of appointing an adjudicator, which may take a month or two, depending on the rules and the arbitral body that you're using. And of course, you've then got the cost of the adjudication themselves. And so if a successful party were forced to go down the arbitral route, then that might, particularly in the case of small adjudication awards, be something of a substantial practical deterrent or obstacle to enforcement. On the other hand, there is nothing in the Construction Act that would explicitly preclude the parties from adopting such a course if they so chose. While the scheme, of course, all parties have to have the right to refer matters to adjudication at any time, but insofar as statutory provision is made for the final binding effect of adjudication, once that's provided for by the scheme, and therefore it's at least notionally possible to effectively contract out of court enforcement. But of course, as we'll see in these two cases, and indeed consistently in the authorities that preceded them, the courts have set their face against arguments that the court's jurisdiction to enforce is ousted. And these two cases while leaving open the possibility that on the terms of a particular contract, the issue might be solely one for an arbitrator. And the reality is that they effectively sound the death knell for this sort of technical argument. In the Sefton case, there was a further issue raised, and it may be useful just to linger on that at the end, in that a waiver point was also raised. I mean, no criticism of opponents in this matter, but it was raised in his scale as an argument. And there were criticisms by the judge of the manner in which that waiver matter was dealt with in evidence. I will come back to that at the end, because that may be sort of some. There is one practical point arising out of that which is a useful takeaway. On the fact of the case here, the waiver point arose because there was a dispute as to whether or not bespoke amendments in the agreement in fact had the effect of supplanting the adjudication element of the dispute resolution procedure with the CIC model procedure. And of course, you'll see that clauses 4, 5 and 31 of that procedure are relatively clear. It states in terms that the decision is binding until finally determined by arbitration. The decision is to be implemented whether or not there is a reference to arbitration subsequently. And notably, clause 31 states in terms that the parties shall be entitled to redress whether or not the dispute is to be referred to arbitration. And his other Judge Hodge case, he agreed the CIC procedure did apply, but dealt with the waiver point in relatively short order. The crux of the matter for the court was the effect of clause 93.1 of the Net 2 form, which is extracted there in my notes. And essentially, under that procedure, a 4-week time bar is imposed. The starting point is that the adjudicator's decision will be final and binding unless it's challenged. And then 93.1 provides that you have 4 weeks to issue a so-called notice of dissatisfaction. And it's clear on the face of the provision that if you fail to issue a timely notice, that renders the award final and binding, and the tribunal simply has no jurisdiction in the matter. But there was an issue here, though, as to the level of particularity that was required in the notice of dissatisfaction. And certainly, where a substantive dispute is determined by the adjudicator, is to be referred to the arbitrator, that there's no real requirement for any significant particularity at all. That was decided in the earlier case of Transport for Greater Manchester and Kia. But of course, there'd be no reason for there to be any requirement for there to be any significant particularity, because ultimately that would be a matter to be dealt with in a notice of arbitration to follow subsequently. However, here we have the notice of dissatisfaction that was issued in Sefton itself. Notice is given of the dissatisfaction with the decision generally, and it's stated it related to the entirety of the decision, including the conclusions, reasoning and decisions. And the issue that arose was that effective to seize the arbitral tribunal of the issue of the validity of the award? Judge Hodge said no. He agreed it was a challenge to validity of a fundamentally different character, and a notice of dissatisfaction needed to make that clear. Accordingly, there'd been no election to refer the matter to the arbitrator, and it necessarily followed that the issue as to whether or not there should be a stay simply did not arise, because the award was final and binding, even if the arbitrator had jurisdiction over the matter, if the notice of dissatisfaction had encompassed a validity challenge. But on the stay point, Judge Hodge dealt with that as an issue of construction. That was common ground between the parties. And he relied primarily upon the provisions of the CIC scheme, which I referred to at the outset. They all make clear that the issue is one for a court and not for an arbitrator who simply doesn't have jurisdiction under these forms to deal with issues of validity. And he did add that wasn't a matter of some form of public policy or something that runs out of the Construction Act. It was simply a matter of the interpretation of contractual language, which does raise the question whether it's possible to contract out of the court's jurisdiction to enforce. However, there's an early decision in the matter of MACOB, which was indeed the first ever adjudication enforcement decision, and that particular conundrum is resolved by the courts taking the view that, well, if you elect to challenge the decision through arbitration, you accept provisionally that it is indeed a decision until the arbitrator says otherwise. The terms of the NEC form say a decision is binding until the arbitrator decides otherwise. And once you make that election, the effect is not only that the award is enforceable, but indeed that those, as we'll see in the Doucet case, those arguments can't be ventilated in court if you make that choice. And as I mentioned earlier, there was an issue regarding the manner in which the jurisdictional challenge had been raised. The claimants here had pleaded that no jurisdictional objection had been taken. There was no jurisdictional point taken in the evidence in response to the application. But in a third replying witness statement further down the line, there was an oblique reference to the possibility of a jurisdictional challenge. Judge Hodge said that we'd set ourselves on stall by our pleading. The claimant couldn't be required to prove a negative, and the belated waiver arguments were in any event dismissed on the basis that they were ill-founded. Right, so plainly, if you're going to raise a jurisdictional point, it's clear this has to be the matter has to be spelled out clearly in the evidence in support. That was the Sefton case. Doucet raised essentially the same issues under the NEC 3 form. The state for arbitration was raised on fundamentally similar grounds. Again, Mrs. Justice O'Searle found the notice of dissatisfaction didn't include a challenge to jurisdiction, and therefore there hadn't been an election to refer the matter to the arbitrator. And the effect of that was that the decision was final and binding. And she also said that it would make no sense to require a declaration to be obtained from the tribunal to enforce it, because that would deprive it of its immediately binding effect. And she dealt with the point I raised earlier that there is an election to be made. If you go down the arbitration route, and then you're precluded from raising the jurisdictional points in court. If you don't go down the arbitration route, you can raise them in court, but the matter, the arbitrator then won't be seized of them. And it's right to say that Mrs. Justice O'Farrell did caution that you always have to be astute to consider the express terms of the agreement. But realistically, when one looks at these two authorities, and indeed the preceding MACOB and MBE decisions referenced earlier, the courts have set their face against attempts to oust the speedy adjudication enforcement mechanism. And while there may be some scope for delaying enforcement and forcing parties down an arbitration route through ingenious drafting, it's exceedingly difficult to see what that would be. And therefore, it is fair to say, I think that these two decisions are largely the death knell for these sorts of technical arguments on enforcement applications. Well, that brings me to the end of my talk, and I think we're ready for questions and answers now.
Thanks very much to all three of our speakers, and I hope you enjoyed their interesting and illuminating talks. In fact, you must have done, because there are no questions as such in the Q&A or the chat. Right. But I propose to ask a question which all three of our contributors might want to answer, but perhaps Jonathan first, which is, do the panelists think that the Part 8 challenge to enforcement, which is what it really is in fact consistent with pay now, argue later, where you, in fact, if you win on a Part 8, you're getting a final decision, whereas, of course, adjudication enforcement is only temporary. So perhaps a couple of moments of thoughts on that from all of you. Jonathan, if you don't mind going first.
Yeah, so I think that obviously, potentially, it's inconsistent with the pay now, argue later regime, which is why the courts are very reluctant, I think it's fair to say, to allow parties to get into Part 8 dispute claims willy-nilly on enforcement. And of course, the TCC guide and the authorities, such as Hutton, are very clear that the circumstances in which you can raise a dispute for final determination in the context of enforcement are very narrow. So I think the courts are certainly alive to the possibility that the whole purpose of adjudication might be subverted by the Part 8 procedure. So yes, it's a risk, but that's why there are quite limited circumstances in which you can bring that kind of dispute forward on enforcement.
Sarah or Oliver, any thoughts?
I agree entirely with what Jonathan has said. I do think it's unfortunate that many losing parties in adjudication use the issue of it simply increasing costs and leading to the position where you feel like you have to deal with it and potentially undermining the position. But I also agree with Jonathan that the approach the courts certainly seem to be taking is it's limited. It's limited that we will allow any form of Part 8 to have to make any substantive difference to what has gone on, but the arguments still remain.
Yes, I very much agree. I mean, ultimately, the ability to bring a Part 8 claim effectively in parallel makes it. I mean, in a case where there's been some egregious error and the matter would be resolved could be resolved by Part 8 proceedings anyway. I suppose it's not hugely inconsistent with the basic rationale, but you are getting a situation which is pay now and argue at the same. You can't get a situation which is pay now and argue at the same time, and particularly if you've got a small award and the costs of dealing with some legal point in the more involved fashion that one has to deal with them in court are incurred at the same time. Then yes, it's obviously a potential deterrent to enforcement, and it is something that can be held over at parties a means of levering them down to a settlement on something less than the full amount of the adjudication award.
Well, thank you very much. We're very nearly at 10, so I think we can finish now. Thanks to everyone again for attending the webinar. We hope you've enjoyed it. King's Chambers has a series of webinars, not just on construction, but on all of our practice areas. And we hope that you'll join us or other of our colleagues in our next webinars. Also, the slides from today will be up on our website in due course, and I'm sure that any of the three contributors and me, for that matter, would be happy to answer any specific questions that you have arising out of this by email. But for now, thank you all very much for your attendance. Wish you all a very good day, and bye for now.